Good morning to all of you. This video is for the law of tort students. Friends, as far as the negligence topic is concerned, previously I told you the definition and the very famous case law, Dono versus Stevenson 1932, where the neighbor's principle, the stranger's principle, privity of contract, all of them were negated by Lord Etke and said that yes, there is negligence on the part of the manufacturer of the beer. So you know this case and you refer to my previous video if you get any doubt. Now we are going to discuss a few case laws on the same topic on the negligence. Right? So please, this is an important case, that is DM Dr. M. Maigowda and others versus State of Karnataka 1986. So this Dr. Maigowda, on the eve of the Dasara festival in Mysore, she along with her family member, child, 5 members, they have went for a joyride and they sat on the elephant, but the elephant became panicky and they fell down and received injuries. But the defendant could prove that this was one the number of female elephant. It has participated in so many cinema shootings, and because some young boy he fired a cracker, it got panicky and this incident happened. Previously never such incident happened. The court held that even though they received injuries, even though she filed for a compensation of 9.90 lakhs, so court said no, there is no negligence on the part of the Mawati or Mahout in English record, and no negligence. It is a negative example. Now we'll go to third example. Municipal Corporation of Delhi versus Sushila Devi 1999. So please don't forget these Devis. Number 1, State of Rajasthan versus Vijayawati. Then Municipal Corporation of Delhi versus Subhagwati, and Premwati, State of Rajasthan versus Premwati. Now Municipal Corporation of Delhi versus Sushila Devi. Right, 1999. Right, what happened is Sushila Devi's husband, he was passing by the side of the road in the footpath. Already there was a tree which has become barren, or which has already a dried up tree, and even it does not have the bark also. It fell upon him suddenly and he died. Then the woman filed a case of negligence on the part of the municipal authorities. So they said, no, it's only an act of God, or it's only an inevitable accident. But please remember, the court relied on Municipal Corporation of Delhi versus Subhagwati, that is res ipsa loquitur case, 1996, held that the horticulture department should have checked the trees are lying vacant or lying dried up, and they should have acted. Since they did not take care of the trees properly, since they did not take up the periodical inspection of the trees, so since they failed in their duty, since there is a breach of breach of duty of care, this definitely amounts to negligence on the part of the municipal authorities. Therefore, they are liable to pay compensation. Good case for negligence. Next, we'll go to Surendra Shetty versus Sanjeev Rao, 1982. Right. Actually, this Sanjay Rao was driving a car. When they were approaching a school, when this man was approaching a school, suddenly the school boy, after all young boy, aged about 9 years, so he came across the car. He was walking briskly. Suddenly this boy came across the car, but the speeding car driven by Sanjay Rao hit him, and this boy received injuries. Right. Court held that the driver should show care and caution, due care and caution. That's why in near the schools and the temples, the clearly signboards will be there. School area, go slow. School zone, go slow. Temple, be silent. Like that, the warning signals will be there, but people don't care. So Sanjeev Rao went in a rash or negligent manner with a speeding car, as a result of which the boy was hit by the car and died. His father, Surendra Shetty, he filed a case. Now the court said that the driver should have been more cautious. Please hear the words. Driver should have been more cautious, and responsibility is cast on him. There is a responsibility on him to control the speed near the places like the schools and temples. They should have stopped the vehicle. At least even though he was driving the car. When the boy, normally we don't expect the boys to come suddenly. When the boy came suddenly, at least he should have stopped the vehicle within a moment's notice, but he should not have dashed him. So here, negligent driving. Negligent driving is proved. So in this case, you have to remember 2 points. One, school zone. Second is they should be extra cautious or more cautious. Then go to the next. Glasgow Corporation in London. Glasgow Corporation versus Taylor, 1922. Right here, this Glasgow Corporation, there is a municipality. They grew up actually herbal plants, particularly some of them are poisonous in nature, but they look like blackberries. So they look like, but these municipal corporation people, they did not actually display that they are poisonous trees, or they did not give any warning to the general public. So along with the herbal trees, the plants, these plants are also growing up. And the car is a public park, so many people will have entry into it. So some of the children lured by the berries to be blackberries or red berries. One child aged about 7 years, he has consumed those berries. Of course, since they are poisonous, what happens? This boy died. So please remember, the court held that the shrub or the plant premises, the shrub was neither properly fenced, no fencing was done, nor any notice displayed. So definitely carelessness, recklessness, negligence on the part of the municipality. The municipality is liable for the negligence. Next case, Jawaharlal versus PCH Reddy, 1975. Right, please remember, whenever you are driving the vehicle, you should not allow any person to be on your right side, particularly the driver's side. Of course, left side also only one person should be there. This PCH Reddy, he has allowed a person to his right side in violation of section 83 of the MV Act. So actually, because of the person, this man's vision, he could not see the opposite vehicle. So just like that Amthi Ben Patel versus ONGC case I told you. So even though he was going to the left side, that vehicle came and hit him. Because of the blurring of the vision by the unnecessary interference of the person on the right side, the court held that there is negligence on the part of the driver, allowing other people to sit on the right side. It amounts to negligence. Therefore, this man, that is PCH Reddy, has to pay compensation to Mr. Jawaharlal. So these are the cases which are not in my notes. Therefore, I am making this video. Please write the case laws, hear the video carefully, and definitely you will be enriched on the topic of the negligence. Thank you very much.